In chapter 8, I think that's everything. Chapter 9, topics that will not be on the exam are page 255, not on the exam. Page 256 is not on the exam. Page 260 through 264 is not on the exam. 260 through 264, not on it. Page 268. Through 272, not on the exam. There is a good exhibit on the top of 268 though, the 1 year rule for the statute of frauds. That's a good exhibit, but 268 through 272, not on the exam. I'm gonna post this as well, this recording of our lecture today, just in case you came in late or missed something. All right, I'm jumping to chapter 17. And nothing on page 495, nothing on page 496. Nothing on 497, nothing on 498. All right, that's all the things that I'm trying to cut out for you. Give this back to Grace. So the exam's gonna be all multiple choice. It will be all open book, open note. There will be no less than 40 questions, but no more than 50 questions. I haven't made it up yet, so I can't tell you the exact, but I'm gonna be within that range of questions. It is only on, remember, contracts and employment law. That's the only thing on there. And I've gone through and told you some pages that you can exclude from your study. I will put on the website today a printout of the examples that we're going over so that you can follow them and you can always listen to this lecture again if you need to. All right, let's go back and let's stay on employment discrimination right now since that's fresh in our minds. Will somebody tell me when it's 8:40, please? And that way I'll know to switch over to contracts. All right. Alice was hired as a receptionist. She's an at-will employee, which means she has no contract. She does good work, but her boss, Mandy, cannot stand her being around. One day, Mandy has had enough and fires Alice. So the question is, does Alice have a case against her employer under the employment law as we've studied in chapter 17? Alyssa's not shaking her head no. Why not?
I'm looking for it in my notes, but you can fire somebody. Is it, employment at will?
That's right. Alice is an at-will employee, and that means she can be fired for any reason so long as it's not discriminatory. Anything in my fact pattern cause any red flags to make you think maybe it was discriminatory? You would also need to know, this set of facts doesn't tell you, and I'll be careful in the exam to tell you, that we need to know whether or not this business has 15 employers or more to know whether or not Title VII is going to apply. All right, Chad is a 50-year-old supervisor. He learns one day that he's being fired and he's being replaced with Corey, who's 31. And the reason that Chad was given was because it was, quote, time for some new blood and new ideas. So based on these facts, does Chad have a case for employment discrimination? What do you think, Mr. Dutton?
I'd say yes, since it's age discrimination.
All right, and what would make you think that it's age discrimination? What about this fact pattern leads you to conclude that?
I'd say since the explanation was new blood and new ideas, that would be the I guess, base that I stand on.
Okay, the new blood and new ideas remark might support the fact that Chad has a case. And remember, it's always going to be, based on the total facts of the situation. But does Chad have a situation that would lead him to believe that maybe he's being discriminated against? Sure. All right, Beverly adopts a child and takes 12 weeks off to care for the baby. Let me stop right there. Can she do that? Is she entitled by law to have 12 weeks off to care for an adopted child? She is. And what law gives her that right? Come on. The Family and Medical Leave Act, right? That's family and medical leave that she's asking for. When she returns, her former position has been filled by another employee. Is that illegal in and of itself? No. Mr. Walker says no. How come?
Her position can be filled, but she has to, I think she's entitled to her position, but like, I forgot.
A substantially similar position, right? Okay.
Yeah.
What if her pay is just a tiny bit less than her other position? Then the question becomes whether or not that's substantially similar to her old job, right? Okay, good. All right, Janice applies for a promotion, but she's passed over for another employee. Janice is female. She's passed over for another employee who is a man and who is younger than her, but who has been at the company longer than Janice. Does Janice have a case based just on those facts? Not based on those facts, right? Ms. Flagg, what would you say on that? Let me take it a step further. If the employer gives as the reason to Janice that she didn't get the job, that it was because they were going on based on seniority, then that would support Janice not having a good claim, right? What if the employer made a comment that they just didn't feel like, like Chad, like they needed some new blood, or let's see, that her ideas were just getting stale, then that might be a different thing, right? So recall too that, remember the way the burden shifts in an employment discrimination case? Let's go back to Chad for a second. If Chad sued for age discrimination, then he's got to go into court and show that he was qualified for the job, and that he feels like, and that he was a member of a protected class, and that he feels the reason he was fired was because of his membership and the characteristics he has that place him in that class. In Chad's case, that would be a person over the age of 40. Then the burden shifts to the employer to then articulate a non-discriminatory reason. I doubt that the employer is going to go into court and lead with, we needed some fresh blood and new ideas. The employer is probably going to try to go back and see what they could find to say Chad didn't do a good job, or his performance was substandard, or something like that. And then once the employer has thrown out their reason, then the burden shifts back to Chad to prove that the employer's reason was really just a cover-up for discrimination. Remember, that was the burden shifting, BS for burden shifting, and I also call that the BS defense. Chad has to prove that his employer's reason for firing him was in fact BS. All right, Lance applies for a job in a women's dress shop. He's turned down because the duties of the job include helping customers in the dressing rooms. What do you think about that, Megan? Does Lance have a case? How come? All right, so some certain discrimination could be legal as long as we would call that a bona fide occupational qualification, right? We need to have women in the women's dressing rooms. Or a business necessity. It's necessary to the welfare of our business that we not have men in the women's dressing rooms. What if Lance applied for a job as a salesperson in the women's dress shop and he was turned down because the owner of the dress shop felt like that they wanted women to sell dresses to women? Then does Lance have a case? Grant's nodding. Why do you say yes?
Because that's not a job that really needs to have a different requirement, so that's definitely a case that you can.
Right. There's no business necessity to saying that only women could sell dresses to women. Right. I'm sure that there are plenty of men who could not sell dresses to women, but it's certainly not true of all of them. Yes.
So what if it was like a shop that was kind of their thing where they try to like get women to sell women's dresses? It's just part of their process, not necessarily saying men can't do it, but like just saying
Like if part of their brand or their
Yeah.
mission was we're employing women
Yeah, like they wear clothes from the shop, try to show off, and
that they wanted the salespeople to be able to promote their clothes.
Yeah.
Because we have seen that.
Yeah.
In fact, wasn't somebody in here talking about that? Wasn't that this semester?
I don't know, I had a story that was kind of similar, because I worked at a dress shop, and all our salespeople were the people who help in the dressing rooms. However, we were trying to hire a guy because we wanted diversity, and so it felt odd to me, because I was like, but we're in the dressing rooms, like helping the ladies, and they said, oh, but like, that's actually what helps some sales, like some lady will come in here and be like, I want a guy salesman, but we didn't have any, and so that actually made our sales like go up, so it was like a weird concept.
Huh. That is interesting. Back to Carrie's example though, what do y'all think about that? What if the mission of your business and the brand you've built is on employing women to wear these clothes and sell dresses to women? What do y'all feel? Do you think Lance would have a case in that instance?
I think he would if he was willing to do it.
You think he would still have a case if he was willing to? I think he would still have a case. I think that while that's great that that's a part of the brand and everything, that still could be seen as discrimination. Y'all may be too young to remember this, but this was a huge deal with men suing Hooters for not being hired as wait staff. And they won because, Hooters was not hiring men without cleavage to, serve the wings and stuff. And that was found to be discriminatory. But didn't somebody in here say they were modeling clothes as part of their job at one point? Oh, Miss Anderson did. Okay. Do you know why I remember that?
Right.
Because when you said something about I was a model, every boy's head in here that was either looking down at their phone or their computer either turned around in their seat or looked up and looked at you. You'd like that just set off a little alarm when you say model. Guys, you know who you are. All right. Jason is an at-will employee and he has no contract. All right. If he did have a contract, he would no longer be an at-will employee. So just because we're in an at-will state, Once you sign an employment contract, that takes you out of the at-will status. So Jason is at will. His boss, Johnny, says that he will fire Jason if Auburn loses that weekend's game to Georgia. After Georgia beats Auburn again, Johnny fires Jason. What do you think, Lauren? Does Jason have a case against Johnny?
I mean, most likely, 'cause it had nothing to do with the job, like, at all.
But he's an at-will employee.
That's still kind of messed up.
Still kind of messed up, but our question is it legal?
I guess so.
Wrong, immoral, a terrible thing to do, all those, but we're talking about legal.
Okay, wait, did the employee agree to it? Cause then would it be a verbal contract?
There is no contract going on here. Because Jason would not have agreed to lose his job if Georgia won. Like, you're thinking like if there's a bet.
Well, if he was like, hey, if like Georgia wins this weekend, yeah, kind of like a bet, kind of like.
So in my example, there is not a contract, but in her example, what would be missing? What element would be missing of a contract? Say that again. Consideration, because Jason hasn't given up anything, right? I mean, Johnny is saying, I will fire you if Georgia wins, which is the flip side of saying you can keep your job if Auburn wins. But we don't have a contract there because Jason hasn't given up anything of value. If they had made a bet such as, let's make a bet that if Georgia wins, Jason loses his job, but if Auburn wins, Jason gets a promotion. Then we've got some consideration. I would be very reluctant to mix contract and employment law on y'all. I wouldn't do that to you, but I just thought that was an interesting way to look at the element of consideration. All right, ABC company hires salespeople based upon a standardized written test, and they will hire the applicants who score the best. So over the past 2 years, they've had a pool of applicants that consist of 50% women and 50% men. Based only on test scores, 90% of all of the new hires were female. Paul and a group of males who were not hired want to sue for discrimination. So, do we have intentional discrimination in this example? Anybody want to argue that we do? Anybody want to argue that we have? Okay, hold on, Mr. Walker does.
It really all depends on the test that's being taken, because the company could have a test that's more leaning toward what a woman would be, score higher on than a man.
So what do we call that kind of discrimination? That's the unintentional discrimination, or the word for it is disparate impact. Remember, disparate treatment, that's intentional discrimination. I didn't hire you because you were male. I didn't promote you because you were male. There's nothing on its face discriminatory about saying I'm going to give a test and I'm going to hire the people who score the best on it, right? I mean, you can't examine that statement or that basis in and of itself and find something discriminatory in there. But the law does allow you to look at the results of a larger sample size and infer unintentional discrimination or disparate impact. All right, Connie works the information desk at a large airport, and after her leg is amputated for medical reasons, she requests a high stool to sit on while she's at the information booth. Her employer denies the request because they feel it would not look good to have her sitting while all the other information booth employees are standing. Does Connie have a case for employment discrimination? Ms. Chapman's nodding yes. If you nod yes, I'm gonna call
Okay. The Americans Disability Act, she's protected by that.
her. Okay. And what did she, what, under the ADA, is that you've identified the correct law, what did Connie ask for?
A stool.
And what would we call, what would that be a request for an accommodation, right, under the ADA? And is the reply, are all employers required by law to give whatever accommodations are requested? No, they have to be reasonable accommodations, right? They have to be reasonable. So we would look at Connie's case and say, is her request to have a stool, is that reasonable? Yeah. And remember, you still have to be able to be qualified and able to do the job without the accommodation. So Connie, she's already had this job. She clearly has the ability and the qualifications to be in this position because she's done it before. She just needs a stool to make it easier on her physically. So that is a reasonable accommodation. How about this one? Johnny applies to a women's clothing company for a job as a runway model for their latest fashion line, but he is rejected specifically because of his gender. I think we can assume some facts that might make this not as clear cut as you might think from the beginning. So, just based on what I read out, what do y'all think? Does Johnny have a case?
So he was applying to be a model for a women's clothing line?
A runway model for a women's clothing line.
I wouldn't hire him.
All right, so Carrie says no. All right, so let's start thinking of some facts that might make it harder on Carrie. What if Johnny is one of those models that you can't tell? You have a really hard time just looking at him to tell if they're a man or a woman. What if his appearance is such that if you didn't know, you would have to have him tell you? What if the clothing line was for cold weather outerwear, where he's going to be wearing a hat and a scarf, and really all you can see is Johnny's eyes, which are beautiful and very feminine? What if the clothing was a two-piece bikini? You can see how the facts could change things, right? We clearly can't hire a man to model on a runway a two-piece bikini. But should he be denied just on the basis of his gender if he could model the clothes just as well as a woman could and the audience and the people watching couldn't tell? I don't know. I'm not going to give you questions on the test that you're going to sit there and be like, well, if this and this. It's going to be hopefully more clear cut than that, but I just want you to see how, remember, throughout this course, we always talk about it depending on the facts of the case. And you need to always be able to let your mind wander a little bit and think, well, what about this or what about this? What assumptions have I made here that might not be true or that might affect the answer? None of you seem to be buying any of my arguments, though, on Johnny. So, you still not going to hire Johnny, Carrie?
I would have a hard time with it. I would have really hard time. Just knowing, because I mean, like, it is a women's clothing line.
It is a women's clothing line. I think that is not a bad defense. What if the women's clothing line became popular with men, and all of a sudden there was some article of clothing that it became fashionable for men to wear from this women's clothing line? You can just see where it's possible to, and these are the facts that end up going to court, right? The easy cases don't end up going to court because everybody can look at an easy case and know that, you know, whether Johnny should be in the women's restroom, that's not a hard case. But whether Johnny, who by all intents and purposes looks to the naked eye like a female, could he model women's clothes? Maybe not quite as clear cut. All right, it's been a big year for Janice. She is an at-will employee at a large company. She had a baby 9 months ago. Her parents are celebrating their 50th wedding anniversary, and her husband just returned from being deployed overseas. So to celebrate, she has planned a cruise for her family, and she has requested leave under the Family and Medical Leave Act. Her request is denied, She goes anyway, and when she comes back from her cruise, she learns that she doesn't have a job anymore. Does Janice have a case against her employer under the Family and Medical Leave Act? Who says yes, who says no? Well, let's go back and look at this for a second. Family and Medical Leave Act requires, let's go back and look at the definition and see if Janice meets it. Well, if I can find it. Here it is. All right, so first of all, Janice has to have worked for her employer for over a year. I don't think I mentioned that, but we're assuming that she has. So be careful not to get tripped up by that. If Janice had been working for her employer for 10 months and she requests family and medical leave, they can deny it because she's not eligible yet. You've got to be there a year. So she could ask for leave to care for new children. Does she have a new child? She had a new child in this fact pattern 9 months ago. What about to care for an adopted or foster child? We don't have that. To care for seriously ill spouse, child, or parent? We don't have that. To care for themselves if a serious health condition prevents performing essential job functions? She didn't have that. So the only possible way she would qualify would be if she is requesting the leave to care for a new child. Now, my fact pattern said it's been a big year for Janice. She had a baby 9 months ago. Her parents are celebrating their 50th wedding anniversary, and her husband just came back from deployment. So to celebrate, she plans a cruise for her family. Do you now think, having read the definition, that Janice would qualify for family and medical leave? Probably not, because the reason she gave was that it was a celebration. What did Janice do wrong in her request? What should she have said? E. She should have said, I need 2 weeks off to care for my baby, right? Okay. The employer could probably know that Janice was full of it and she's really just, planning a cruise, but the employer's stuck in that situation because she has articulated a legal reason for requesting leave. Grant.
Isn't she entitled though because her husband came back from deployment?
So there is part of the definition on deployment, so I'm glad you brought that up. She could take leave to deal with a non-medical emergency arising out of the fact that her spouse is a covered military member on active duty. So if there's something about her spouse's active duty that brought up an emergency, like that they had to move, or let's say that her husband, this happens all the time around here, is going out in the field or going on some training mission, or her wife is going on some training mission and going to be gone for 2 weeks, and Janice needs the leave to care for the family while her husband is gone. Nobody is sick. There's nothing medical going on, but there is a family emergency created by the military service. So that is part of the definition as well.
You can't call it a celebration.
You just can't, that's right. She called it a celebration. I don't know the answer to this, but I'm curious as to how far an employer could go to verify the reason. So, for example, the health department, that's one of my clients, when we have a request for a medical leave, we require some documentation from a physician that the employee needs the medical leave for themselves, or if it's for a family member. But we don't require documentation, and we wouldn't require documentation as to why you'd need 2 weeks off to care for a baby. I guess we would just require documentation that you did in fact have a baby. I'm thinking through the list. If you had a foster child placed in your home, I think it would be okay for the employer to say, can you give me the verification that you have a foster child? I mean, I think most of these reasons could be verified pretty easily, and so I don't think it'd be discriminatory for the employer to ask for the verification, but I do think employers might get in some kind of little murky waters if they start arguing with the employee about whether or not that's really something you need to be off work for. You know, if your toe is hurt and you all of a sudden can't, you know, say you need medical leave from your desk job. I don't know, I'm making things up, but again, I don't want any of the questions on the test to be confusing in that way, but you do need to remember that there are always nuances to these laws, and there are always exceptions to the laws. So you do need to go through in your mind, like Grant did when I was reading the list of reasons, and I did leave out the one about the spouse being on active duty. So it's not just, does this law cover this situation, but let me run through the exceptions as well and make sure that that I haven't run into any of those. Ashton. 845. All right, thank you. One more employment then. Johnny is an at-will employee at a medical billing company. He discovers that the company is overbilling insurance companies on purpose, which is a crime, and he reports them to law enforcement. He is fired once the company learns that he was the snitch. Does he have a case for employment discrimination? He does, because that is what? He's protected by what? What kind of law do we call that? To protect people who turn their employer in. Those are the whistleblower laws, that's right. You can't be retaliated against for turning in your employer for being a criminal. All right, we're going to switch over to contracts. So just a quick review. Remember, a contract has to have 4 elements. Agreement, that's offer and acceptance. Consideration, capacity, both parties have to have capacity to enter into a contract. And legality, the contract has to have a legal purpose. You have all 4 of those things, you have a contract. Do all contracts have to be in writing to be enforceable? No, thank you, good. Anybody says yes, I will fight you right here because you have not been listening. All right, so Betsy hires Frank to transport a shipment of cocaine for her in exchange for $100,000. They have an offer and agreement. They have consideration. They both have capacity. Do we have the element of legality? No. You cannot enforce a contract that has an illegal purpose. So the element of legality is not satisfied, and therefore no contract. Johnny offers to buy Keith's goat for $50. Keith says that he would sell the goat for $55. Can Johnny enforce the contract? If Johnny claims that they had a contract for $50, no, let me back up. Johnny offers to buy the goat for $50. Keith said he would sell it for $55. Do we have a contract? We do not. Why do we not have a contract? Right, we don't have the element of agreement. We had an offer, and then we had what? A counteroffer, right. That's right. When a counteroffer is made, the previous offer is then terminated, rescinded, goes away. So if Johnny said, let's take that one step further. Johnny says, I'll buy your goat for $50. Keith says, I'll sell it to you for $55. Johnny says no to the $55, and then Keith says, okay, I'll sell it to you for $50. Do we have a contract then? We don't, right? What do we have from Keith? Another offer. We just have another offer. I accept an oral job offer to teach here for fall semester last year through fall semester of 2025. Do I have an enforceable contract with CSU? Why not? They offered, do we have an agreement? They offered a position for me to teach for 5 years. I accepted. We have an agreement? We do. Do we have consideration? They're gonna pay me to teach here. I'm gonna teach, they're gonna pay me. We got consideration. We both have capacity. Is it legal for me to teach here? Yeah, I guess so. So we have all the elements of the contract. So what would be wrong with, what would be a reason that is not enforceable? So that, go ahead, E. I can never tell who's talking, I'm sorry, with your mask. Go ahead, Grant.
I said length of time.
Length of time, but what specifically is wrong with the length of time? And the type of contract I have? It's over a year. And what does that affect? I mean, we can have legal contracts for over a year, right? So but you're right. What is the problem though with the length of time versus the type of contract I entered into? Walker.
If it's over a year, it has to be in writing.
That's right. Okay, so we've got this is a statute of frauds issue. And the statute of frauds, remember, says that the contract has to be in writing to be enforceable if it cannot be performed in less than a year. So for me to teach from 2020 to 2025, could I possibly perform that contract in less than a year? No. What about if the contract it's an oral contract still, what about if the contract was for me to teach here for the rest of my life? Does that have to be in writing? Who says no? Why doesn't that have to be in writing, E?
Or you can die tomorrow. So.
I could die tomorrow. I could this contract could be performed in less than a year. Statute of frauds is ridiculous. And remember the lesson we took out of all this? Don't do oral contracts ever, right? Always put it in writing. All right. Johnny's friend Randall owns a cattle ranch. One day, Johnny asks Randall if he ever thought about selling the ranch. And Randall replied that, as a matter of fact, I'm planning on listing it next year, sometime next year, for around $1 million. So the next week, Johnny sends Randall a check for $1 million and a note that says, "I accept your offer to sell the ranch." We got a few problems with this scenario. So what's one of the problems that we see right off the bat?
You didn't actually offer it up yet, like you said, in a year, I'm thinking about selling.
Right, so statements of future intention are not offers. Okay, so she's right. We don't have an offer in this case for Johnny to have accepted. Statements of future intention are not offers. Let me change that for a second and say, Randall says, I will sell you the ranch for $1 million. And the next week, Johnny sends him a check and says, "I accept your offer to sell the ranch for $1 million. Now do we have, all of this communication was oral. Now do we have a contract?
Did they agree on it at the time?
Well, the offer is out there. He made the offer. He never took it back. Johnny accepted it within a reasonable amount of time. So, I like the way you're thinking. Johnny did it the next week. What if next year Johnny accepted it? Maybe time has passed to get that offer terminated.
It probably would not.
But there's one big glaring problem with this example. What is it, Mr. Dunn?
Doesn't it be the price is over 500 or 5,000?
So, all right, so contracts for the sale of goods over 500 have to be in writing under the Uniform Commercial Code. We don't get into that. And it would have to be the sale of goods by a retailer or someone in the business. So you're on the right track as to that setting off a red flag, but that's not the specific reason we don't have a good contract here. Yes.
When you're selling land, don't you have to have a written contract?
Yes, and why is that? What is it that requires that? The statute of frauds, right? Statute of frauds says that, and remember, statute of frauds is a extremely misleading name for the law that says which contracts have to be in writing or not. I wish it was called the contracts that have to be in writing law. That would be a lot easier for us. But it says that contracts that can't be performed in less than a year, like we talked about a minute ago, and contracts for the sale of land have to be in writing. So because this was a contract for the sale of land, it would have had to be in writing. I do think that both contracts and employment law are so full of exceptions and if this or but that, that don't just rely on today's lecture or stuff you've heard in class. You really do need to go back through your notes and the text and really make sure that you understand all of the this, but that, or and that. There are a bunch of really good exhibits and charts in your text that I think are great for helping you get that, sort that out in your mind. All right, Johnny buys bread from Lisa to sell at his convenience store. They don't have a written contract. Lisa makes deliveries every week, and the two have been operating under this oral arrangement for 4 years. Last week, Lisa stuck her head in the door and asked Johnny the usual, and Johnny nods his head yes. Is that an enforceable contract? So first of all, can we base an employment just on, can we base a contract just based on behavior of the parties in the past? We can. Can we have a contract if the terms are not expressed out loud, either orally or in writing? In other words, can we have an implied contract? We can. And when we have those situations, we look at objective things. Remember the objective theory of contract. What's the past behavior in dealing with these folks? What would a reasonable person who has been in that situation, what would they think? Would the reasonable person who had watched Lisa stick her head in the door and ask Johnny if he wanted the usual every week for the last 4 years know what that meant? Yeah, probably so. So again, it's the objective theory of contracts that is going to govern what we look at when we get into things like implied contracts, contracts based on behavior, contracts based on things that are not expressly written or expressly said. Johnny offers to buy Keith's Corvette for $50,000, and Keith rolls his eyes. Johnny later informs Keith that they have a contract because Keith's silence was an acceptance. Who says no to that? Everybody. Who else says no to that? Raise your hand. Anybody say yes to that? Good. That's not a contract. I was just seeing if I can make y'all doubt yourselves for a minute. Silence is not an acceptance. Even if Johnny said, I offer to buy your Corvette for $50,000, and if you don't say no out loud, then I'm going to assume that you've accepted my offer, right? You can't. That's also not a valid acceptance. What if Johnny said, I offer to buy your Corvette for $50,000, and if you accept my offer, roll your eyes. And Keith rolls his eyes. Then do we have a contract? Yeah, that would be a hard argument to make, right? What if Keith was nonverbal and had no mental disabilities or developmental disabilities at all, except for that he couldn't talk? Then could we possibly have a contract? Possibly. What else would you want to know before you decide whether there was a contract on that? Madison?
You said he rolled his eyes as agreement?
Yeah.
But how do we know that him rolling his eyes is a way to say yes as compared to like doing a thumbs up or something else?
Right. So that would be a fact against Johnny, right? Why didn't you pick something that we would all understand to be acceptance, like nodding your head or thumbs up, rather than rolling your eyes? That was a dubious thing on Johnny's part. But yes.
And rolling your eyes is like a thing. It's like on personal opinion, because I can do this when I look to the side, and somebody can sit down and just roll my eyes and really don't just like thinking about it, you know.
What if Keith made the argument that I did roll my eyes, but it was a twitch because I I felt something, I just had an itch or something that made me roll my eyes, or I heard a noise up on the ceiling and I was really just looking up on the ceiling. Would those be good defenses? I mean, probably so, because objectively it's hard to say that if we were just in there watching, objectively it might be hard to say that we could say for certain that that's what Keith was doing. What if Johnny said, if you accept, jump down, turn around 3 times, squat down, and then sit back down?
I mean, it takes a lot more effort to do all that.
Yeah, I mean, Keith's gonna have a harder time saying that he just did that for another reason, right? Of course, this is all ridiculous because they can write this down, but I just like to do this exercise to get y'all thinking. What if Keith sold cars all the time? That was his hustle, and everybody knew that Keith's way of saying yes and agreeing to things was to roll his eyes. Then we got a pattern of conduct that would make it harder for Keith to then go back and say that he was rolling his eyes for another reason. Yes.
I was also gonna ask, like, the amount of time, like, did he ask that and then Keith immediately rolled his eyes, or was it like 5 seconds later?
That's a good fact. That's right. What about the amount of time that passed? I've made up just a ridiculous example. But it worked because I'm getting y'all thinking about what if this or what if that. And you can see how, a person can get themselves into a contractual situation pretty easily. I mean, it doesn't take any sort of degree to get bound to a contract. So I like the way you're thinking on that. What about if Johnny hires a hitman to kill Carol Baskin? We have a contract there? Why do we not have a contract there? Why do we not have a contract, Joaquin? It's not legal, that's right. Not legal. Johnny has a horse. It's worth $25,000. Money gets tight. He offers to sell it to George for $18,000. George accepts. But when it comes time for George to pick up the horse, Johnny has decided that $18,000 is not a fair price, and so he backs out of the agreement. Can he back out of it at that point? He can't, because of why? What is it about the element of consideration that's going to bind him? Remember, the courts are not going to get into whether the consideration was adequate. Sufficiency of consideration is in the eyes of the beholder, and if Johnny needed the 18 grand at that time, or put it this way, the court's not going to get into the reasons about why Johnny may or may not have agreed to the 18 grand at that time, because Johnny could go into court and make up all kind of reasons. But the court is, remember, under the objective theory of contracts. We're not going to go back and allow somebody to testify about what was in their mind at the time. As with everything, there are some exceptions. So let's say that Johnny I've written this wrong, so let me get it straight in my head. Okay, Johnny wants to buy a Porsche, a fancy Porsche. And Ellen hears from her friend Alex about Johnny wanting to buy a Porsche, and she's in the market to sell her Porsche. So she emails Johnny an offer to sell him the car for $400. She meant to type $40,000. Johnny knows this is too good to be true and probably a typo, but he immediately emails his acceptance. Do they have a contract? So would Ellen have a defense under the adequacy of consideration? Could she go into court and say, this car's obviously worth more than that? Why would I sell it for $400? Is that going to work with her in court? Court's not getting into that. But the facts in this situation that would be in her favor are that Johnny knew that she'd made a mistake with a typo. So he can't profit off of a mistake that he knew she was making. If car was worth $40,000 and she accidentally typed 20 instead of 40, then we have a different situation, right? I mean, who's to say that it's obvious or Johnny should have known that she was making a typo? I don't think that you could get into that in this case. That's why I made it extreme, 400 versus 40,000. Johnny tells his employees that he will sell his watch, to the first one who brings him a check for $500. He meant to say $600, but he said $500. Gene brings him a check for $500. Do they have a contract? Yes, that's right, because Johnny said $500. The fact that he meant $600, that's his fault. The mistake was his. It was not Gene's mistake. Johnny sold Matt, who is 17, a car. Matt makes all the monthly payments before he turns 18, and then he continues making payments for the next year. Can Matt get out of the contract at the end of that next year? He can. He could have, what would have been the window when he could have gotten out of that contract? Within a reasonable time after turning 18. Within a reasonable time after turning 18, that's right. What if Matt had made the monthly payments for 2 months and then changed his mind and tried to get out of it? 2 months after he turned 18. Then that's a closer case, right? Yeah, what if Matt shows up on his 18th birthday and calls Johnny a sucker and turns the car in and tells him that he has no contract? Then he's good, right? He did it within a reasonable amount of time after turning 18. Max is 21. His old Aunt Eve tells him that if he stays celibate until he is married, she will give him $10,000. Max gets married at age 25, and he has remained celibate his entire life until that point. Does he have a valid contract that his Aunt Eve has to pay him the $10,000? Let's assume we had an offer and acceptance.
You're saying that he did accept whatever she said?
Yeah, he did. I'm sorry. Yeah, she offered and he accepted. He said, "You got a deal." So we've got that part. Assume we've got legality. This is not illegal. And assume that everybody had their right mind. They have capacity. Do we have any issues with consideration? E.
They have consideration, but how can you prove that?
Well, right. So he skipped right to the point that everybody thought of first. How would you ever prove that? I guess Aunt Eve's lawyer would have to do some discovery and try to track down all of Johnny's romantic partners over the years and get them to say under oath what happened. But does the fact that Johnny didn't, well, let me ask you this way. What was Johnny's consideration? I mean, Eve's consideration, she's going to pay him $10,000. Did Johnny satisfy the element of consideration? He didn't do anything actively, affirmatively, but he gave up something. So not doing something, forbearance from doing something, not taking action can be consideration. So the fact that he didn't actively or purposefully take any action, I guess what I'm trying to say is his inaction was consideration. That can be consideration. Yes.
That sounds weird, but I actually knew somebody that happened to. Their parents said, like, you don't do anything until you're married, like, pay for your honeymoon.
And
I don't know if that's a little thing.
did they get the payoff?
They're not married yet, but they're not going to get the payoff.
Okay. Well.
They literally told me it's not worth it.
Okay, they declined the offer.
They didn't, because they got it when they were young, and then they sort of, like, got to college.
Okay.
And they were like, forget that.
I didn't
And then
know.
they broke
So
off.
they may have accepted it later on, but now they have abandoned any intent to perform their part of the contract.
Would that be considered like just breaking the contract?
Have they breached the contract? So that's a good question. Have they breached the contract? I think that the way this is worded was that Eve would give him the money if he didn't do it. If the wording was, I will give you $10,000 and you will agree that you won't, then we may have a breach of that contract. If so, they may, your people, may want to go back and check the terms of their agreement, right?
Yeah, I think it was just like, if you don't, if you do, like, you're just not getting.
Well, were they under the age of 18 when they agreed to it? So then we wouldn't have a capacity, they wouldn't have capacity, right?
Yeah, because it was in high school.
Mm,
That's
okay.
what you're doing.
So I'm gonna think that they do not have the capacity to enter in that contract. All right, we only have, I think we've covered everything I want to cover. I want to give y'all a minute if anybody has any questions for me. Yes, ma'am.
I guess I do have something I was curious about. So what is the case like you're at an auction and so they have a starting bidding price and then when nobody bids on it, so then it drops and then people start bidding. It gets up to a certain point, but it doesn't get up to the point that the person really wanted for it. But people keep bidding and they get to a point and it stops and the guy says sold, and then the guy comes back and says, well, I don't wanna sell it unless I get this much for it.
So the question is about an auction, and auctions have, I'm not gonna say special rules, but if you're in the formal auction process and you want to not sell below a certain price, you gotta specify that. That's called the reserve price. And that way everybody knows up front that if it doesn't reach the reserve price, then the person's not bound to sell it to them. But if it's just in his mind that he didn't want to sell it until it got to a certain price, he's out of luck.
Yeah.
Because objectively, there's no way for the buyers and the bidders to have known that. Any other questions? Yes, ma'am.
When's the final?
The final is going to be open as soon as the final period opens up, and it'll be open until the last day of finals.
So it's online?
It's going to be online. Yep, it'll be online.
From Monday to Sunday?
When is the first day of finals? Next Monday?
Tuesday.
Tuesday?
Monday is that day, and then Tuesday they supposed.
All right, so I've got until, so Tuesday at 12 a.m. midnight, it'll be live. And then that goes through what, Saturday, Friday or Saturday? Friday? Okay.
No, I do have a question.
Yes.
Did you hear anything, like, they have to be online? Because I've got one professor, I heard one professor was like, yeah, they have to be online, and one professor was like,
If I got that email, I don't know.
okay.
I have not heard that. But I don't always read all my emails from CSU. Or I know y'all are about to say or from us either. I do try to read y'all's emails. Just maybe not always the same day. Any other questions? Okay. I do want to mention one thing, and I don't want to be a downer at the end, but I did send this out in the announcement yesterday. I do have a strict attendance policy, and I have bent that somewhat this semester because we have COVID, and I'm not dropping anyone for missing more than 4 absences, which is what you're allowed. But if you're a person who has excessive absences and you haven't ever talked to me about it or come up to me to talk about some reasons, then that could affect your grade. And when I say could affect your grade, I mean things like if you're borderline or, I didn't put it in the syllabus, and so I don't think that I've got the right to go in and dock you necessarily. And I'm not looking to do that. It's making myself sound like a jerk. But I was real explicit at the beginning of the semester that is an important part of the class for me, is that you come. And so that could, if you're a borderline grade, then that is something that could keep you from getting over and above or, jumping up to the next one. So I just want to mention that. I hate to be like that, but that is the deal, so to speak, that everybody signed up for. All right, I'll be here for a while after class if anybody needs to talk to me. Good luck to y'all. I appreciate you getting up at 8 o'clock in the morning and coming to class and letting me call on you and participating. It makes class so much better when you have students who are engaged and active. And I do know that y'all have been that this semester, and I thank you for that. If I can ever be of help to anybody in the future, please give me a call. I don't do criminal law, so if you get arrested, I can't help you there. And probably a lot of other areas of the law you wouldn't want me to help you with either. But anybody ever needs any advice or needs something from me, by all means, give me a shout. Y'all have a good weekend, a good end of the semester, a good summer. Anybody graduating this semester? Have any graduates? All right. Keep up the good work.